Hello, everyone. Am I on? Can you hear me? Hello? Let's try it again. There we go. Hello, everybody.
Hi.
How are you? Everybody have a good weekend?
Wish I was still there.
Okay, let's get started. We have 3 bill hearings today and hopefully a little time left over to work a couple bills. So we'll get started with Senate Bill 483. I'll open that hearing and we'll have Natalie give us an overview.
Thank you, Mr. Chairman. Senate Bill 483 would increase the criminal penalties for theft and criminal damage to property involving remote service units, such as automated cash dispensing machines and automated teller machines. Section 1 amends KSA 215801, that's the crime of theft, and it sets penalties based on the value of the property or services stolen. So subsection C currently there defines value as the value of the property, or if the property is regulated scrap metal, the cost to restore the site of the theft of such regulated scrap metal. This bill would add that value means the value of the property, or if the value is a remote service unit, the cost to restore the site of the theft of such remote service unit to its condition at the time immediately prior to the theft of such remote service unit, whichever is greater. Remote service unit would be defined as the same as in the state banking code. It includes, but it's not limited to, automated cash dispensing machines and automated teller machines. Section 2 amends KSA 215813. That's the crime of criminal damage to property. Current law there in subsection B defines aggravated criminal damage to property as criminal damage when the value or amount of damage exceeds $5,000 committed upon certain buildings or structures with the intent to obtain any regulated scrap metal. This bill would add the aggravated criminal damage to property would include criminal damage when the value or the amount of the damage exceeds $5,000 committed upon a remote service unit with the intent to obtain currency. Current law there in subsection F provides that in determining the amount of damage to property, damages can include the cost of repair or emplacement of that property that was damaged. And I can take any questions.
Representative Heiberger.
Thank you, Mr. Chair. Natalie, could you tell me what in page 2, line 34, what currency upon a remote service unit means?
So that's essentially that is trying to obtain money from a remote service unit. The reason that it's phrased like that is to mirror what is there for scrap metal. So that that verbiage is used there, damage upon those buildings. And so that is trying to obtain that currency from something like an ATM machine.
Then does it include the damage to the machine also?
Yes, yes. So that is included under that remote service unit. So it includes the damage that could be incurred by that machine. So
okay,
it would be like the amount of money that you get from the machine or the damage that you caused to the machine when you were trying to get the money out.
I got it.
Any other questions for Natalie? Representative Wheeler.
Thank you. And I think you explained this once, but it went right over my head. What is a remote service unit as opposed to automatic teller machine, which dispenses cash, ATM?
That is one version of a remote service unit. And I should have put the definition there that's in 9/11/11. I can get that for you and read it, but it would include automated cash dispensing machines and automated teller machines. An ATM, as you know,
what an automatic teller machine is. I know what an ATM is. They're very familiar to me, unfortunately. What is an
ATM is an automated teller machine.
Right. What's a remote? Where is it now?
Yeah, the remote service unit.
Automated. Yes.
It includes, I don't know what else it includes. That's why I'll have to find the definition for you from 9/11/11, but it includes also automated teller machines and automated cash dispensing machines.
Okay, thank you.
Any other questions for Natalie? Thank you, Natalie. We'll begin with proponents, Kelly Manswell. Did I get that right, Kelly? Okay, good. I usually don't, so it's be good for a Monday.
It's a tough last name, very Dutch. Mr. Chairman and committee members, thank you for the opportunity to testify today in support of Senate Bill 483. I am Kelly Manswell, Assistant Vice President of Government Relations at Kansas Bankers Association. A little background on the KBA. We were founded in 1887 and our membership includes 99% of the 220 banks and savings and loans headquartered in the state. I'm here today because across the United States, there's been a rise in the theft and destruction of ATMs. The Wall Street Journal actually reported that it's doubled within the past year. And over this past year, the KBA began to receive communications from our members about attacks happening here in Kansas. These smash and grab attacks are organized crime. It involves a team who gets a stolen truck and a hook. They hook it onto the ATM and rip it out of the ground. They either take the ATM with them or they break into it and take the cash canisters. I've actually attached some pictures to the back of my testimony from attacks here in Kansas that illustrate it. With hearing about how frequently these attacks were happening, we sent a survey out to our membership in early February, and the results we got back were worse than we had expected. And a lot of our banks report that even just one attack with the delay it takes to get back to function can really damage a community. For some perspective here, an ATM machine can cost, it varies from about $30,000 to $80,000 per machine. And then an interactive teller machine, which is just a more advanced version, it has more technologically updated software. It can take deposits. Those machines can be closer to $100,000 per machine. And then due to supply chain issues, just like everybody else, it's taking weeks or more like months to get the parts or a whole new machine needed. And with that time, especially in the smaller communities, they're without access to that financial resource that whole time. Since 2020, we've had more than 35 ATMs attacked across the state of Kansas, which has caused more than $1.3 million in damage to property, loss of cash, and in incurred security measures, whether that's more cameras or more steel poles around the ATMs to try and keep them in place. Our banks are trying to get creative, but having a difficult time stopping these attacks still. This is usually where we get asked, don't banks have insurance on these machines? We do have insurance, but the frequency of the attacks is causing our insurance premiums and deductibles to skyrocket. Really, when it comes down to it, in communities all across the state, but specifically smaller communities, the theft and destruction of the ATMs is limiting their access to financial resources. Partially due to COVID, but also just due to the shifting technology landscape, more and more customers are relying on ATMs for their transactions. And in the smaller communities with the limited number of financial institutions, when an ATM machine goes out, they can be really impacted. We view this as not just a crime against banks, but a crime against communities. I'll give you an example of a bank in southeastern Kansas that has been hit multiple times. Because they've been hit so often, their insurance costs have gone up $30,000, and they're now forced to make the decision of can they financially afford to maintain this ATM machine. It's the only one in the community, so they want to offer this to their members, but the prices are just becoming astronomical. Senate Bill 483 would increase the penalty for both theft and criminal damage to property. As the revisor stated, I do want to say I made an error in my testimony there on what the criminal damage would be increased to. It would be up to a level 6. I accidentally left in where it was currently at, so I just want to be clear on that. Theft would go up to a non-person felony from level 5 to 7, depending on the amount, and the criminal damage would go up to a non-person felony level 6. Remote service unit was mentioned. So this is a definition that we pulled from the Kansas Banking Code, and ATMs and ITMs are considered remote service units, just kind of the banking terminology for an ATM, but it includes both of those. As I said, this is a problem that's coming across the United States. Last year, Texas passed legislation to increase their penalty. This year, Missouri, Oklahoma, and Arkansas are looking at similar legislation. So our worry is if we don't pass this, we could be last man standing if everyone around us is kind of tightening their security. Thank you for your time today. I hope that when you consider Senate Bill 43, you can see the importance of it and you look at it favorably. I'm happy to stand for questions at the appropriate time.
Okay, committee, any questions? Representative Heiberger?
Thank you, Mr. Chair. I may be misunderstanding something. Where in the bill is the increasing the penalties for theft? Is that included in the language on, new language on section 2, line 34, et cetera?
To me, okay, I guess, yes. I believe that's in section 1 on, or on page 2 on line 15, where we add in remote service unit under theft.
Okay,
And the revisor can correct me if I'm wrong
I
there.
thought you referenced that this bill increased penalties for theft. Did I hear you wrong?
I'm sorry, I believe I did state that. Am I misunderstanding the question?
I'm trying to figure out whether I'm misunderstanding or you are.
Could I have the revisor help us out here?
Yeah, Natalie.
Thank you, Mr. Chairman. I think that what's intended here is that the change will actually come from the definition of what a value is. So we're adding the value of that remote service unit. And so that is where the increase comes, because we're including that there for the increased penalties.
So it wouldn't just be the cash, right? It would be the cash and then the cost, the amount of the remote service unit.
Right,
So that's the increase.
Okay, thanks.
Yes.
Representative Humphreys.
Thank you. That was a great question. Appreciate that. So just out of curiosity, are these geographically, the 35 that you had in 2020, were they, I mean, I'm trying to think of the ones, in high traffic areas. And then I know are those ATM machines that are actually in like Quick Trips and stuff, are those the same, or is that something different? Because I'm thinking those probably don't get.
So our survey just covered the ATMs that were owned and operated by our members. So the bank. So if their bank has most banks wouldn't have it in a Quick Trip, but it just depends where the bank ATMs were. I'm sure this is happening to other ATMs who are independently owned and operated. And the 35, the tax that we had come in from our members were across the state, ranging from Kansas City, Topeka, Wichita, and then even western rural parts of the state as well.
And the pictures in your testimony were like daytime, or was it that just night cameras? Or
no, that's daytime. That is it. They were caught in that instance. It's hard to catch them because they're usually very fast. They were caught, and then that is from the next day when the sheriff's team was there to kind of take the pictures of the damage that had been done.
Okay, thank you. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, and thank you for being here. You said these people are very hard to catch. Will increasing the penalty or changing the law make it any easier to catch these felons?
Well, they are hard to catch. Some of them have been caught. And so for those that we do catch, I think having this increased penalty fits the crime. And then I'm also we're hoping that, if we pass it and all the states around us pass it, it's kind of a deterrent in our area.
Do we have any evidence whatsoever that increasing the penalty for this already felony will in fact deter the commission of the crime?
I do not have any evidence.
Thank you, Mr. Chair.
Any other questions, committee? Okay, thank you, Kelly.
Thank you.
Next, we have Stephanie Mulholland.
Thank you, Mr. Chair. Thanks for having me, committee. Stephanie Mulholland here on behalf of Heartland Credit Union Association. We represent the 74 credit unions that are headquartered in Kansas. Just want to add our support for Senate Bill 483. As Kelly mentioned, we're seeing an increase in the number of these crimes based on insurance company estimates that these smash and grab crimes jumped from 220% from 2019 to 2020, and then followed by a 257% increase in 2021. I did lay out in my testimony a few reasons why we think this is happening, but would draw your attention to the last two. One of those is during COVID, it led to a lot of more people doing business with ATM, and as COVID has subsided, they've continued to do more business with ATMs, which means those machines are stocked more than they normally have. Which has made them a bigger target. Second reason is as we look to other states around us increasing these penalties, we're concerned that these penalties may not be punitive enough to deter criminals from these types of crimes. Kelly really touched on the majority of it, so I won't repeat what she said, but would say that due to the current supply chain issues, we're finding it takes longer to replace these machines than it normally would. And so in lower income neighborhoods or neighborhoods where people work the night shift and the ATM might be the place they normally do their business, we're finding that's an extra burden on those families. And so with that, I'm happy to take questions and ask for your support of Senate Bill 483.
Representative Heidelberger.
Thank you, and thank you for being here, Stephanie. Stephanie, do you know in those instances where the perpetrators are caught, are they being prosecuted or are they not being prosecuted like we heard for the hospital crimes?
So I will say from the credit union perspective, I'm not aware of a credit union ATM theft where we have caught the person. But my understanding is there may have been some others caught on ATM crime and that there has not necessarily been prosecution.
Representative Carmichael.
Thank you, Mr. Chair. And with your leave, I might be able to provide the representative a partial answer. I was told by proponents of this bill that in Labette County, the prosecutor refuses to prosecute these crimes because the penalty is not strong enough. I wrote to the prosecutor and passed that information along to him and have not heard anything from him. I contacted the Prosecutors Association to see if I could get an answer from them. No answer forthcoming. There was a question, though, for our proponent that's now escaping my mind, but it'll roll around here in just a second.
Lucky Stephanie.
Yes. This is, the question is, this conduct, I think, is already a violation of Kansas law. You're wanting to increase the penalty. Is that correct?
Correct.
Okay. Is it a violation of federal law?
I am not familiar with how this applies on ATMs. I know with an actual financial institution robbery it is. But I apologize. I'd have to get more details on how that applies to an ATM.
Mr. Chair, if our proponents don't know the answer, could we perhaps ask legislative research to take a look? Because my suspicion is that there are much stronger penalties available under federal law for this crime than even what we're proposing here under state law, but I'd like to get an answer to that.
We'll have Bob look into that for us. Thanks, Bob. Any other questions for Stephanie? Okay, thank you.
Thank you.
Committee, we have written proponent testimony from the Community Bankers Association of Kansas. Any other proponents? Do we have any neutral conferees or opponents? Not seeing any. I'll close the hearing on Senate Bill 483. Next up is Senate Bill 395. I'll open that hearing and again have Natalie come back up.
Thank you, Mr. Chairman. Senate Bill 395 imposes restrictions on surveillance of private property by employees of the Kansas Department of Wildlife and Parks. Current law in KSA 32808 requires the Secretary of Wildlife and Parks to employ conservation officers and other officers. This bill enacts a new section of law that prohibits those employees from conducting surveillance on private property unless authorized pursuant to a lawfully issued warrant, court order, subpoena, the Constitution of the United States, or one of the following exceptions to that search warrant requirement, which would be exigent circumstances, consent searches, or the plain view doctrine. The Senate amended this bill to provide that the provisions of subsection A would not apply to any activities of an employee of the Kansas Department of Wildlife and Parks when the purpose of the surveillance is to locate and retrieve a missing person. The term surveillance is defined as the installation and use of electronic equipment or devices on private property, including but not limited to the installation or use of a tracking device, a video camera, or audio recording device to monitor activity or collect information related to the enforcement of laws of the state of Kansas. And I can take any questions.
Questions for Natalie? Representative Humphreys?
Thank you, Mr. Chairman. Is there a definition of exigent circumstances?
Mr. Chairman, Representative Humphreys, there's not really a definition of that. That's pretty well defined in case law, so it's kind of a fact specific. Those exceptions to the warrant requirement come from a long line of Fourth Amendment search and seizure doctrine. So there's not a definition in statute, but.
Okay, thank you.
Representative Heiberger, then Wheeler.
Thank you. Well, you can punt this one if you want, Natalie, but does this bill as amended prohibit anything that's not already prohibited by law?
Mr. Chairman, Representative Heiberger, the proponents could feel free to opine on that. But as you're well aware, the Fourth Amendment to the United States Constitution has, a well-established case law of lawful and unlawful searches and seizures of private property.
Representative Wheeler.
Your Honor. Boy, that comes from years of service. Mr. Chairman, I think I will reserve my question for a proponent.
Very good. Any other questions for Natalie? Okay, thanks, Natalie. Proponents first up is Representative Ken Corbett.
Thank you, Your Honor. Committee. The Bill of Rights, the Fourth Amendment says, the right of the people to be secure in their persons, their houses, their papers, their effects against unreasonable searches and seizures should not be violated. If a county sheriff, the FBI, your chief of police all need a search warrant, I think a game warden should have one too. And I know a lot of you, whenever you decide to run for office, everybody up here has something they're more passionate about than others. But I don't know how you could go home and tell your constituents that you let this right get away from them. I urge you to pass this bill, and I'll stand for questions.
Any questions, committee? Representative Wheeler.
Thank you, Mr. Chair, and thank you, Representative Corbett, for coming before. I do want to make sure that I understand what you're proposing. First of all, I want to ask, because I'm understanding that Wildlife and Parks officers now are certified law enforcement officers. They have to go through the law enforcement training center, just like any other officer. Why are they excluded, under your opinion, from the Fourth Amendment?
They seemingly are. Maybe the open fields doctrine, maybe something. But on the flip side of that, Representative, the passage of this bill also would give the department a little protection if they would have maybe a renegade officer kind of go off the path, and it might give them an out to save some of their hide.
Is Wildlife and Parks, as a matter of policy, to your knowledge, sir, allowing their officers to go on people's land without permission, without all of the exceptions, or are they really allowing that as a matter of policy?
Well, the trouble to that is you won't know, and you may never know. You may never know whether you were surveillanced. You may never know you have a game camera at your front gate. And it's just not for rural property. I mean, the way that it is right now, they could come into your house and say, Mr. Wheeler, I'd like to check your freezer.
May I? And then term surveillance is defined as installation and use of electronic equipment devices on private property. What about surveillance, things that are gazing into your property but not on it? Is that covered under this bill?
Well, I think that would be kind of a borderline thing. You'd be, you may not be on there, and that may be something they'd want to skirt on that. But I would, if I was the one being camered on, I would take offense to it.
Okay, but if you understand, we're dealing with the letter of the law. What about drones flying over and gazing down in? Our technology has changed since.
I would say that would be surveillance.
It's very important that we keep these things concise.
So basically, I would say that would be. I mean, I'm just saying on your property, why? Why would you or any of your constituents want to give the blessing for a government agency to trespass and surveil upon your property?
Representative Corbett, I'm not asking these questions to oppose you, sir.
I know it. I'm just answering your question.
And I may have to defer to Representative Carmichael, but it seems that there is a doctrine that you own your land from the land up, but I'm not certain if I'm correct on that, and I'm sure Representative Carmichael can correct me. Thank you, Mr. Corbett. I appreciate your testimony.
Thank you, sir.
And it's an interesting issue in Kansas.
Just trying to protect you, my man.
Representative Corbett, one more question. You almost got away. Representative Carmichael.
Couldn't see him. Yes, Mr. Representative Carmichael.
Mr. Honorable Representative, Your Honor, a pleasure to see you in our committee. And yeah, there's a whole doctrine of law about aircraft flying over and surveilling your property. The general rule is if the aircraft is where it has a right under the FAA rules to be, then it can be there and it can look. But if they have to violate the federal aviation rules in order to get down low enough, then it may be a violation, but I don't know the law as to drones. You can say, thank you.
Thank you, Mr. Carmichael.
Okay.
And I didn't mean to belittle the importance of the legislation. It's just that the distinguished representative and I have been friends for many years, and it's a pleasure to see him in our committee.
Next, we have Jackie Newland.
Good afternoon, Mr. Chairman and members of the committee. I'm Jackie Newland, Associate Counsel with the Kansas Livestock Association, and I'm here today in support of SB 395. For KLA, it really comes down to a private property rights issue. So essentially what this bill does is it's a limit on the open fields doctrine. This doctrine limits application of the Fourth Amendment to unlawful search and seizure to the home and the area immediately surrounding the home. And it leaves out the rest of those private property rights, including farm and ranch land, which our members consider to be of the same importance as their home. So they'd like to see the same protections extended to that land that they already have with their home in that immediate area. Therefore, we believe that all government should have either permission, a warrant, or exigent circumstances in order to be able to enter onto that land and conduct surveillance measures. Additionally, this bill was amended on the Senate floor in a number of ways. KLA overall supports those amendments with one exception. We do oppose the elimination of the term physical presence from the definition of surveillance. I'm not sure why that was eliminated in the amendment, if it was an oversight, but as it stands now, it only allows for electronic surveillance, and we'd like to see there be specifically physical presence as well, or else that severely limits the ability and capabilities of this bill. So with that, I won't rehash anything that we've already discussed here today, and I'd be happy to stand for questions when appropriate.
Any questions, committee? Representative Carmichael?
Thank you, Mr. Chairman. I'm a little bit confused about this amendment and why you oppose the amendment that was put on over in the Senate as it relates to physical presence. So let me try to work through that with you. The bill as originally proposed in the Senate proscribed, I believe, wildlife and parks from being physically present on the landowner's premises to observe for potential violations of game laws. Is that a generally correct understanding?
Initially, it said either physical or electronic presence in the initial language. That was stricken to say the installation and use of electronic equipment or devices on private property.
And so as you understand the bill as now amended, wildlife and parks enforcement folks could be physically present upon the land, but they could not use electronic surveillance measures on the land of the landowner without consent.
That's correct.
When I was a little boy, we used to fish at a place called the Cow Pond, and you couldn't see the Cow Pond from 45th Street North or 37th Street South or from Oliver. And it made a wonderful place for people to go fish without a license. And the only way that they stopped folks from fishing without a license was that every now and then the Wildlife and Parks, the game warden, would come over to the pond and say, "Hello, boys, how you doing today?" And then they'd look at our stringer, and then we'd say we're under 16, nanny, nanny, boo boo. But it sounds to me like if you were to re-implement the physical presence prohibition, that would prevent the game warden from catching those miscreants down at the cow pond, because the only way you can see that good fishing hole is to enter on private property. Is that what you're asking us to add back in, if you will, to the bill, that Wildlife and Parks can't come on the property to look for people violating the game law?
Without consent or warrant, or those exigent circumstances where they believe a crime might be committed, and other reasons that fall under case law for exigent circumstances.
But you're not objecting to Wildlife and Parks sitting on the road with binoculars if they can see the cow pond and observing Representative Carmichael out there poaching sunfish.
If they can see it from that public property, then we have no problem with it.
And then would that constitute the exigent circumstance such that they could enter and enforce the game law, as you understand it? Okay, thank you, Mr. Chair.
Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here. Could you tell us what, in your opinion, what this bill would prohibit that's not currently prohibited under current law?
So I believe, and this isn't to the physical piece, I believe this really stemmed from a Tennessee case where the equivalency to Wildlife and Parks had come onto private property and placed an unmarked camera. And I think that was where the concern came from, is the individual found the camera. It was unmarked, so he removed the camera and then was subsequently in trouble with law enforcement for taking down government property. So I believe that that's the origin of all this. That would be one circumstance.
But that would not be permitted without a warrant under current Kansas law, would it?
We don't have anything that specifically goes to that. It's being litigated currently in Tennessee. And so I think that's where the concern came from. Thank you.
Representative Wheeler.
Thank you, Mr. Chair. And in response to Representative Carmichael, to being able to observe through binoculars miscreants fishing in the cow pond somewhere, I think in the vicinity of Wichita, does not, thank you, Representative, does not give that officer probable cause to believe that those miscreants are without a license, right? So they still couldn't go in. What if we just excluded the cow pond from this bill?
Seems a little specific, but
Thank you, ma'am. Thank you, Mr. Chair.
thank you.
Representative Carmichael.
Thank you, Mr. Chair. Just to set everyone's mind at ease, the cow pond is now Eagle Lake in the city of Bel Air, Kansas, and it is a park open to anybody and everybody except during closed hours. Thank you.
Representative Schreiber.
Okay, I think I've been listening to Representative Carmichael too long. So if, yeah. Oh, it's on. If a wildlife and park officer is in a public right of way and somebody's hunting on private property across the fence, can they ask to show your license? Can I check your game? Or
I believe so. On that would be public property, and so they would be able to approach them and ask them anything that they wanted to. And if they saw them over there and they had reason to believe, especially say that someone were deer hunting on off season and you saw somebody, you could clearly go, if there was a crime being committed that you could see it directly in front of you, you would clearly be able to then enter onto that and ask them. I would say as was noted, there isn't exactly a specific definition for exigent circumstances, but something that's commonly come about through case law. If I'd be allowed to read, I do have circumstances that would cause a reasonable person to believe entry or other action was necessary to prevent physical harm to officers or persons, destruction of evidence, escape of a suspect, or some other consequence improperly frustrating legitimate law enforcement efforts, which is fairly broad. So there is quite a bit, I think, that would fall below those circumstances and allow them to be able to still conduct their job as they see fit.
Would the hunters be compelled to, I mean, if they said, no, I don't want to show you my license, and went on hunting on the private property, I guess maybe I'm getting way far too deep
I
in the
can't
weeds.
speak to specific circumstances. I mean,
Okay.
I'd leave that for
Okay.
court. So
Okay.
I won't go down that rabbit trail too far. Sorry.
Understand. Thank you.
Representative Wheeler.
Thank you, Mr. Chair. And if I may, a question for Representative Corbett.
Or any additional questions for Jackie? Okay, thank you. He thought he was off the hook, so of course we'll bring him back up.
Well, I just want to make sure that I'm understanding, because back in my days when I was actually able to hunt, it was not uncommon to be out in a field, privately owned, walking through the stalks, hunting for pheasant or dove or quail. And the game warden would stop and come out to check our licenses. Also check to see how many shells we had in the shotgun. Would this bill prohibit that officer from going onto the ground for purposes of enforcing the fish and game laws of the state of Kansas? I'm just asking what your opinion is.
Probably if he thought, two thoughts on that. If he thought that they were violating, that's one thing. But normally, from what I've been told, the wise thing to do is to let them wait on public roads to where they find their vehicle or their house, and let them come out with what they've got and ask them there, and then as chase them through a field. You know what I'm saying? For both for their advantage and everybody else's.
I do know what you're saying, and I know it makes sense. I'm just asking whether or not this would prohibit the officer from going onto the ground to check there, because that's what they used to do. I know they did.
Yeah. I guess what you're saying is you're assuming that the people who are hunting are in violation of something.
I am not the officer. The officer is checking to see whether they have valid licenses and whether they have adequate plugs in their shotguns. He has no knowledge that they have no license, but that's the way it used to be enforced. This would change that, right?
I don't think it's going to change it that much. This is more into the protection of your private rights, your Fourth Amendment stuff. And I don't want you to get, I mean, I understand your question, but it kind of diverts a little bit from your eye on the ball. What I'm more concerned about this is kind of like if you had a tracking device on your truck and didn't know it, or if you had maybe a camera in your garage or your barn and you didn't know it. I just think that if everybody else in law enforcement that you know, from the FBI to the sheriff, has to get a search warrant, why in the hell wouldn't you have a game warden do it? I mean, it just seems like common sense to me.
Okay, thank you. We're going to move on to our next proponent, if John still wants to come up. John Luth.
Thank you, Mr. Chairman, members of the committee. My name is John Luth. I'm the Deputy State Director of Americans for Prosperity. We view this as a relatively simple bill, so I will try to keep it relatively simple and relatively quick. The first and foremost thing I want to address right off the top, though, is something that you may have heard from opponents of this bill, and we've heard a few times, and that is simply this. This bill is not an anti-police bill. This bill will not stop wildlife and parks from doing their jobs. This bill will not stop them from investigating the things they need to investigate. All this bill does is ensure that proper due process is upheld and that Kansans know that their private property rights are upheld here and will not be trampled in the name of convenience or in expediency that is not already a legally upheld precedence. This bill, to quote something we heard on the Senate floor last week that I think perfectly encapsulates this bill, it is simply this: you can be pro-police and you can be pro-rights, and this bill strikes that middle ground. It ensures that our police can do the work that they need to do. Nobody is trying to help the bad guys get away or stop the good work that needs to be done. But what we are trying to do is ensure that private property rights are upheld, regardless of whether or not we're talking about somebody's house, a field that they own, the back nine of their woods, a dog house, a garage, or a barn. If there is going to be a search or a surveillance done there, the proper legal processes need to be followed and proper due rights need to be followed. And that is what this will do. It simply brings us into alignment with that due process. One quick thing here. According to the Kansas Department of Agriculture in 2017, there were nearly 60,000 farms in the state of Kansas. That's nearly 60,000 Kansas citizens with a usually large swath of property, usually not immediately next to their homes, that without these protections are living at risk every single day of having their property intruded upon and surveilled upon and being completely in the dark about it. This bill closes that loop. It ensures that Kansans never face that reality without proper due process and legal processes followed. And it ends that practice by suspending the rights of your private property and due process reach by no longer asking questions such as, how close is this piece of property to someone's house? Is this piece of property enclosed or inside an enclosure that also includes someone's house? And most egregiously, one of my favorite questions that's been asked during court litigations over pieces of legislation similar to this is simply, what steps did the resident take to shield from view of passersby this piece of property? So, Mr. Carmichael, to get back to your question, I suppose that the pond in the back with all the woods might already qualify under that. So I am happy to take questions at the appropriate time, but at the end of the day, folks, we view this as simply what I said at the top. This is a bill to strike the balance between being pro law enforcement and pro enforcement of law, as well as pro private property rights, and ensuring that Kansas citizens know that they are not going to be stepped on here in the state. I'm happy to take questions.
Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here. I appreciate your energetic presentation. Did you hear the question that Representative Wheeler asked to Representative Corbett?
I apologize. Could you ask it again?
Oh, well, I'll try to ask it. In the situation that Representative Corbett described, where we have individuals hunting on private property, the game warden shows up and asks to see their licenses and their shells and their guns. Mm-hmm. Yeah, are you telling us that this bill, the way it's currently drafted, would not prohibit that?
This bill would prevent them from entering onto that private property. However, just like any other time that a game warden walks up to a citizen, especially as Mr. Corbett said, if it were to be on public lands, which we know that they will enter that public land to enter and exit that private property, they can walk on that. Or if it matches up with one of the exceptions that are outlined, such as an accident circumstance, plain view doctrine, a consent search, so on and so forth, they could enter in that. But as this is written, no, they could not just enter a private property without meeting one of those qualifications.
John, just to clarify, the Senate struck that language the way I'm reading it. So I believe they can enter onto public property.
Yes. So with the strike of the physical presence, that has come into question. I had not noticed that, candidly, until today, so I've not had a chance to fully examine that. But I would say that based on my understanding of it and from the conversation I've had with fellow conferees that previously spoke, we would also likely be friendly towards the amendment that they had mentioned to ensure that we capture that physical component.
Okay. Additional questions? Very good. Thank you. Let's see, we also have written proponent testimony from Sam McRoberts with the Kansas Justice Institute. Any other proponents? Any neutral conferees? Any opponents? Come on up. I wasn't sure what you were either. We don't actually
Thank you. I had
have you on the list, but
I had to check. Yeah.
I thought with you sitting here, you were likely to come on up. So
Thank you, Chairman Pat.
yes.
I'm Brad Lovelace. I'm Secretary of Wildlife and Parks, and we do have neutral testimony for Senate Bill 395. The reason why we're neutral, we participated in the hearings in Senate Judiciary, and it's been a little confusing to, I'm sure, for the committee to listen today. A lot of folks were talking about the original form that this bill was in. It got amended, and some important amendments were made in the Senate. So the bill you see before you today, we are neutral to, because we feel like it won't have substantial impact on the way we can do our job. To the point that was made, we don't consider it to be really anti-law enforcement the way it's amended, the way it appears before you today. So we are comfortable with this, and it's this current bill that I'd like to address if I could. Couple points, just two really. This bill would have no actual impact on wildlife and parks functions. We have a long-standing history of protecting and defending private property rights as part of the work of this agency. As was mentioned, a lot of properties in the state of Kansas are very large. The owner, if they live there, may not have be able to get around and see all the parts of their property frequently. We have a lot of non-resident landowners, and they kind of count on us to keep an eye on things when they're away. We have a really good history of that. And importantly, we've never had a complaint that we used bad judgment when it came to going on to private property and doing our work and protecting the rights of those private property owners. Not even one, not even one. The other point about this is we have a policy. This bill, as it's amended, really focuses on that electronic surveillance. We can't go onto a property, install electronic surveillance. We discussed this in our agency a year ago when this bill first came up in the House. And we had a thorough discussion and determined we don't want to exercise that right to put a camera on private property without the permission of that landowner or without a search warrant. So we enacted a policy back then that said our officers can't do this. And so the primary focus of this bill as it's written today takes away something that we've already taken away from ourselves. In general, back to the original point about does this change anything that's in place right now? It really doesn't. Other officers, we are certified law enforcement officers, as the point was made before, just like every other certified law enforcement officer in the state. We don't have any more abilities or any fewer responsibilities than they have. They're the same. So it's a little bit puzzling that this singles us out, but that's okay. As it's written today, as it's before you, we are neutral because we feel like the impacts on us would be minimal. Thank you.
Any questions for the Secretary? Representative Humphreys?
Thank you, Mr. Chairman. So before, when it said physical or electronic presence, you were opposed?
Correct. Because the physical part is really important. If we were driving down that country road at 2 a.m. and saw someone loading out cattle, we would want to be able to go in and approach them and say, are those your cattle? Is this your land? Those kind of things. As it was originally written, we wouldn't be able to do that. We wouldn't be able to go on and check hunters to see if they had licenses, had proper number of shells in their guns. We wouldn't have been able to do that as it was originally written in the Senate.
I see. And double checking, the proponents are, they're proponents of the bill as it is written right now, not the way the Senate was. I mean, I guess that's a question for Representative Corbett. You're a proponent the way we have the bill in front of us today. May I ask that, Mr. Chairman.
Yeah, let's swap out for 1 second. Well, go ahead. Well, yeah. We'll come back to Representative Corbett. Any additional questions for the Secretary?
Thank you.
Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here. You stated that you decided not to have your people go on private property and install surveillance cameras without a warrant. And you don't have that authority under current law, do you?
We do have that authority. Every law enforcement officer in the state has that authority currently.
No, wait, to enter on a private property to install surveillance cameras without a warrant from the court or probable cause.
Correct.
And what's the basis for that?
I'm not a lawyer. I just know when we discussed this, my folks told me, sure, every law enforcement officer can do this. It's not done very often, obviously. When we discussed it, we said, this is a right that we don't want to have. So that's why we wrote a policy against it. So our officers wouldn't do this.
You just turned me into a supporter of the bill.
Representative Carmichael.
Thank you, Mr. Chair. Secretary Lovelace, isn't it true there's something known as the open fields doctrine, and that the Fourth Amendment has been interpreted to protect the curtilage, I think it is, the residence and the house immediately surrounding, but not necessarily the open fields that are beyond where the landowner lives and routinely occupies?
Correct.
Thank you.
Maybe with the question, yes, Representative Schreiber.
Yeah, I guess the response to Representative Heiberger made me wonder, can the revisor kind of clarify maybe what is allowed with law enforcement to go on property and install video or audio recording devices, etc.?
She is ready for that somehow. Almost ready.
Mr. Chairman, Representative Schreiber, I wouldn't at this time be able to give you like a very detailed summary of the case law surrounding that, but there is heightened Fourth Amendment protections around someone's actual home. So even if you take one of these homes, say you have like a farm home, the area around their home is protected by the Fourth Amendment more than the open field that's not directly next to their home. And so I can do a more thorough Fourth Amendment case law analysis on that, but that's generally the concept of the open fields doctrine.
Okay. One other question is, so, and I don't know if this would be for Secretary Lovelace or not, but so would this make the exception just for wildlife and parks and not other law enforcement, that they couldn't? Is that okay? So
all three of us are nodding our heads. Yes, someone should say it out loud.
Okay. That's all. Thank you.
Mr. Chair, I might do one clarification. It was referenced a case in Tennessee that kind of got people thinking about this. In that case, the state agency did put up a camera on private property. It was to look at a violation that they had been told was ongoing. That landowner did get in trouble, not because they took down the camera, but because they were violating the law. That's why the camera was there in that case. I don't know if they had a warrant or anything else to put that up, but it was another violation that they got prosecuted for.
Any other questions? Okay, thank you for being here.
Thank you.
Representative Corbett, would you like to come back up, please?
Thank you, Mr. Chairman. So, what question?
Representative Humphreys, going to repeat your question.
Even with the change in the Senate, you are, as I understand, you're a proponent of the bill as we see it right now.
I think the amendment for physical needs to be added to this, so there's like a physical presence on the property, and it's a good thing for everybody, because if you're a landowner and whether you're target practicing or you don't even know what, you'd like to know where everybody is on your property if you can. You know what I'm saying? And Whether they, there's a difference in Kansas between policy. They may have a policy that they do this, and then there's law. I can't imagine anybody sitting here that would go home and tell their constituents, I voted no so that the game wardens could have free range on your property. I cannot understand why anybody would do that to someone they represent.
Thank you.
Thanks.
Any further questions for anyone? Oh, I'm not even looking online. Representative Keither, how are you?
Hi. Thank you, Mr. Chairman. Representative Corbett and others have mentioned that this is from a Tennessee case that I believe was stated it was still in court. Correct me if I'm wrong on that, but are we trying to fix something that's not broken? I mean, how big is this a problem in the state of Kansas? People keep talking about Tennessee, but I don't hear. I've been all over this state and I've been on all sorts of different kinds of property. And I'll tell you, if they don't want you there, they let you know with a lot of signs on their property. So I'm kind of curious how big a problem you perceive this to be in the state of Kansas.
Thank you, Representative. This may be a little bit more proactive and getting ahead of the game. It just seems with the way things are, it's better. I would think it would be better to get ahead of it as not. I don't know. I've read the article in Tennessee, and I personally know of at least one case in Osage County where a camera was used on a neighbor. I mean, they had permission to make it work that way. So I'm just saying it's kind of like having a box of Band-Aids in your cupboard. What could this hurt? It's just like being a Boy Scout, being prepared, and just making sure that your Fourth Amendment rights, you have them.
Okay. Thank you. Thank you, Mr. Chairman.
Okay, we're done with questions. We've done proponents, neutral, and opponents, and there's no one else that wants to speak, correct? Okay, hearing on 395 is closed. Open the hearing on Senate Bill 457 and have Natalie give us an overview.
Thank you, Mr. Chairman. Senate Bill 457 would require a waiver of extradition proceedings as a condition of bond. The bill amends KSA 22-2802. That's the statute in the Criminal Procedure Code that concerns the release and the conditions of that release prior to trial. The bill adds a new subsection C to provide that in addition to any other conditions of release, the magistrate shall order a person to execute a waiver of extradition stating that the person consents to extradition in Kansas and waives all procedures related to extradition if the person is arrested in another state while on bond, and also acknowledging that the person shall not be released prior to trial in any other state pending extradition to Kansas. I would note that this bill is identical to House Bill 2634. That was heard and worked by the House Corrections and Juvenile Justice Committee, and it was stricken by Rule 1507 while it was below the line on general orders. And I can take any questions.
You have questions for Natalie? Thank you, Natalie. We have one proponent in person, Greg Smith.
Thank you, Mr. Chairman. I am Greg Smith with the Johnson County Sheriff's Office, Special Deputy for Government Affairs. Some of you are on Corrections and Juvenile Justice, so you've heard this bill, and it did pass out of that committee favorably, but it was below the line in the House and stricken. On the Senate side, the bill had a hearing on February 16th, and then was passed out of committee, went to the Senate floor, and was passed by a vote of 40-0. What it does is it makes a waiver of extradition a condition of bond if a person is charged with a felony in the state of Kansas. By pre-signing the waiver, it helps expedite the extradition process should the defendant be arrested in another state for other charges. In our case, particularly since we're a border county, this is a huge problem for us. We have folks from Missouri that come over to Kansas to commit crime and then head back over into Missouri. In 2021, the Johnson County District Courts filed a total of 246 fugitive cases. In other words, people that were charged in Kansas and then left and went to another state. Out of those 246 cases that refused to waive extradition, 193 of those cases were from the state of Missouri. The extradition process is very long and it's expensive. And in my testimony, I have a flow chart that I took out of the Kansas Extradition and Interstate Detainer Manual that kind of gives you an idea how that process works. A full-blown extradition can involves the agency that has charges against the fugitive, the local county or district attorney, the Kansas Attorney General's office, our governor's office, the governor of the asylum state, the state that they went to, the attorney general of that state, the local prosecutor where the fugitive was apprehended and possibly charged with crimes there, and then the jurisdiction that has the Kansas fugitive in custody and the court where the Kansas fugitive is being held. If a waiver is executed, there is no need for a governor's warrant. So it takes those steps out of the process. The other thing it does is it adds a protection. The accused cannot be released on bail in the absence of consent without officials from both states. So it would take consent from Kansas and Missouri in order for the person to be released on our charge, not on their charge. This language was borrowed from Colorado, who implemented this law in 2018. We've checked with them and at least with a couple of the counties over there where I have some colleagues, and they have not indicated that they've had any problems since they implemented this law. Also attached a copy of their waiver form that they use in court. In the Senate, the Kansas Association of Criminal Defense Lawyers did not submit opponent testimony. They did in the House Side on Corrections, and my understanding is that they have here today as well. Their biggest concern seems to be that somebody with same name and same date of birth would be arrested in Missouri, let's say, for a charge in Johnson County, and would be erroneously extradited back to Kansas, and they're not the right person. We feel that this is highly unlikely. One, just because we get a hit. Say I stop somebody, if the situation reversed, a Missouri resident in Kansas, and I stopped them and found out that they had a Missouri warrant, I'm going to do more than just verify their name and date of birth, their social security number, addresses, vehicles they drive, driver's license. If they've been arrested before in a felony, the vast majority of states in the United States required DNA on felony arrest, and there's fingerprints. There are numerous ways to identify a person just besides name and date of birth. So I don't think that that's going to be a problem that the wrong person would be extradited back. The idea for this bill was brought to us by our fugitive apprehension unit, and they feel that it would save both time and cost in these types of cases, and I'm happy to stand for questions.
Questions, committee? Representative Carmichael.
Thank you. Nice to see you, Deputy Smith. Welcome to our committee. Let's assume that a large car rental company made a complaint in New York State that I had failed to return a rental car. I haven't been in New York State in over 20 years. Unfortunately, this company is filing these false complaints all over the country. So the court in New York State, they issue an arrest warrant for me based upon the inaccurate statement of the car rental company that I had kept the car. I get picked up here in Topeka, Kansas for jaywalking. They find a warrant for car theft in New York against me. So they arrest me on that warrant. I live in Wichita. I work in Topeka. I say, Judge, bond me out, please. If this bill becomes law, the only way that I bond out is if I waive extradition. Is that the way this works?
You're talking about a charge in New York?
A New York charge, but I'm apprehended in Kansas.
Bill has nothing to do with that.
Okay. That was part of what I wanted to know. So this doesn't apply to anybody else's out-of-state warrant. It's only our warrants.
This is a Kansas felon. If somebody charged with a Kansas felony as a condition of.
Then let me give you the second possibility. That is that Kansas, I'm not a resident of Kansas. I'm a resident of New York. Kansas has a warrant out for my arrest. If this law or bill became law, are you telling me you think that the judge in New York would be prohibited from giving someone a bond because a Kansas law says you have to waive extradition in order to be eligible for bond? Are we trying to tell the judge in New York whether or not somebody can bond out? Is that the way this works?
My understanding is that if the waiver is in place, that bond cannot be granted under federal law.
If a waiver's in place.
Yeah.
But what if the person doesn't waive?
If he doesn't waive, then it's just like it is now.
So the person arrested in New York on a Kansas warrant could bond out in New York. Is that what you're telling us, without signing a waiver?
If they have not signed the waiver if it wasn't part of a condition of bond, then it wouldn't be in place. So yes, they could bond out on a fugitive warrant.
So somebody in custody in New York can bond out irrespective of what we do here. And this bill isn't intended to impact somebody who's arrested in Kansas on a New York warrant. So what in the world does this bill do?
Maybe I'm not understanding your question, Representative.
I don't think you are, sir. Thank you, Mr. Chair.
Representative Wheeler.
Thank you, Mr. Chair. Perhaps I'm mistaken, but it seems to me that this bill applies when a person is arrested for a felony in the state of Kansas.
Correct.
And the person wants to bond out of jail. And the person under Kansas law could not bond out of jail unless that person signed a waiver of extradition to be returned to Kansas should he or she become a fugitive.
Right, as long as it's a felony charge under this bill.
Right. Really doesn't go any further than that, does it?
I'm sorry?
It doesn't go any further than that, does it?
No.
So it really got nothing to do with that New York guy.
That was my understanding, but like I said, maybe I misunderstood the representative's question.
That it's really just about, you commit a crime here, you want to bond out of jail here, you have to waive extradition here, and if you flee, then you waive extradition and you don't have to go through the proceeding.
Correct.
Thank you, Deputy.
Other questions? Thank you.
Thank you.
We have written proponent testimony from the Kansas County and District Attorneys Association and the Kansas Sheriff's Association. Any other proponents? Are there any neutrals? I have listed one written opponent from the Kansas Association of Criminal Defense Lawyers. Any other opponents? Very good. I'll close the hearing on Senate Bill 457. Committee, let's look at House Bill 2674. As soon as Natalie is ready, we'll have her remind us what this bill is about. While she's looking for it, I'll remind you this is a bill that originally came out of corrections, got below the line and was sent to us, and we heard it last week.
Mr. Chairman, House Bill 2674 would require the forfeiture of an appearance bond to be set aside in certain circumstances. And I can take any questions you might have.
Any questions for Natalie? Are there amendments? Representative Owens.
Thank you, Mr. Chairman. I know we've had a chance to work on this, and thanks for the patience in getting this back and getting the language figured. So if we could distribute the amendment. What we attempted to clarify was the process by which the request was made for the entrance into NCIC. If you recall, there was also some clarification on whether misdemeanors and felonies should be entered and how that should proceed. So once everybody has that, I will explain how we have hopefully solved that.
Very good. So just a few seconds here. Okay, I've got it.
All right. So what we did here is, if you see there next to the balloon, line 10, shall declare a forfeiture of bail and issue a warrant for the defendant arrest. That applies to misdemeanors and felonies. So if there's a failure to appear, a warrant is issued. Then we go on to say, if the defendant is charged with a felony, the sheriff shall enter such warrant into NCIC within 14 days of issuance. And if such warrant is not entered into such index, the sheriff shall notify the court. So instead of having anybody make that request to the court, trying to make a motion, so forth and so on, the statute just says that they shall do it. And by the way, this was worked on with law enforcement, and the way that the sheriff's department actually preferred that it happen this way. If you'll scroll on down a little bit more, that's where we clarify the 14-day issue, where it basically says on line 6 on page 2, a warrant that is required to be entered into NCIC pursuant to subsection A was not entered in 14 days of issuance unless there was good cause shown for the failure to do so. So those are the remedies for the forfeiture. Basically, it is rewording what was already agreed to, but clarifying misdemeanors, felonies, who applies to NCIC, and the process is cleaned up just so that there's clear direction. And I'll stand for questions.
Would you like to move your amendment?
Yes, and I'll move my amendment as well.
Is there a second? Representative Wheeler, discussion. Not seeing any. Representative Owens, you may close.
I close on my amendment.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Any further amendments? Okay, is there a motion concerning the bill as amended? Representative Owens?
Thank you, Mr. Chairman. I make a motion that we recommend House Bill 2674 as amended favorably for passage.
Second by Representative Neely. Any discussion? Seeing none, Representative Owens, you may close.
Close.
Heard the motion, all in favor say aye. All opposed say no. Motion carries. Affirmative votes wanting recorded: Hoheisel, Carmichael, Heiberger, and O'Hoppeson. Who did I? Oh, Representative Neely. Mixes that up every once in a while. Catching me off guard. Okay, now let's look at 2582.
Mr. Chairman, House Bill 2582 would direct the Kansas Department for Children and Families to share certain information with investigating law enforcement agencies.
Any questions for Natalie? I have an amendment, Natalie, if you'd like to get that distributed. This is another one that was sent back to us to take another look. We looked at the Cora concerns that were one of the reasons it got sent back to us. We looked at that pretty closely. Natalie looked at that as well, and we didn't determine there was really any changes we needed to make. We felt pretty confident that there's nothing to be concerned about there. But this amendment would just add a sentence indicating that the records, such records shall only be used for the purposes of investigating the alleged or substantiated report or investigation of abuse or neglect. When that comes, you'll have a chance to look at it. Okay. The amendment's on the second page of the balloon, which is page 6 of the bill. I will move the amendment. Is there a second? Representative Concanon. Discussion. Seeing none, I'll close. All in favor say aye. All opposed say no. Motion carries. Any further amendments? If not, is there a motion concerning the bill? Representative Concanon.
Thank you, Mr. Chair. I move that we pass out House Bill 2582 favorable for passage.
As amended.
That's amended. Thank you.
Second by Representative Schreiber. Any discussion? Seeing none, Representative Concanon. May close.
Close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Affirmative votes being recorded. Representative Neely, Hoheisel, Carmichael, Heiberger, and O'Hobson. Committee, that is it for today. Let me, for tomorrow, continuing on our possibly work list is 2556 and 2495. We have 3 more bills we will hear tomorrow. I think it's 3. Is it 3? Couple, 2 or 3, 4, something like that. I think it's 3. The other change is the meeting on Thursday. We will not be having a meeting. Currently, the agenda says, I think we'll work bills, but I generally, unless we need to, do not work a day before pro forma, and did not realize Friday was a set pro forma day. So we won't work Thursday. We'll come back next week. No, KU plays at 1 o'clock. So unless Chairman 2, I don't think I can make the KU game. If it was at 6, I would have made the KU game, but unfortunately it does not work. So any questions about what the rest of the week looks like? We have 1 bill hearing on Wednesday, and we may work some bills then. We'll just see what happens between now and then. I'll let you know tomorrow. So that's it. Thank you all. We're adjourned.